May it please the court. My name is Adam Strong. I'm here on behalf of the appellant Jimmy J. Kinsler. And ma'am, if I could please reserve 4 minutes of my time for rebuttal, please.
That'll be fine.
Your Honors, first let me take this opportunity to...
Move the microphone, if you would, over in front of you.
Pardon, sir.
I think it's...
Your Honor, first let me take this opportunity to say thank you for the ability to argue this case. This is my first time presenting oral arguments before this court, and I do consider it an honor to be here.
I'm glad to have you here.
So this appeal stems from the Hancock County Chancery Court's ruling ordering the appellant's specific performance under the terms of a sale agreement for the purchase of real property. Now, to give as brief of a background to the case without reciting the entire appellant's brief, the parties had entered into an agreement for the purchase of land in Hancock County. This purchase agreement was on the standard Tennessee realtors forms that every real estate agency that I've ever seen uses. Within that language, there is a clear statement that says that the appellee, in this case, as the buyer, had to provide proof of funds and for the ability to close on the property within a certain amount of time. If the appellee did not provide that proof of funds, then the appellant had the ability to then come in and request compliance. And at that point, if the if the appellee did not provide the proof of funds to close, then the appellant had the ability to terminate the agreement. It is appellant's argument that on February 19th, a request for proof of funds was made, and that this was the controlling proof of funds. And to step back for just a second, the appellee, after the contract had been signed, did not provide the proof of funds, and just to be in all candor to the court, they were still within the original time frame that was allowed for them to provide the funds on their own, proof of funds on their own volition. The appellant's real estate agent, towards the end of that time frame, made a written request for a compliance and provide proof of funds. The appellee provided a screenshot of a bank account that had no identifying information other than just, this is the balance that's within this bank account. Here's the last few digits of a bank account number. Don't know where the bank was, no other identifying information, and offered that as proof as required under the agreement. And it is our position.
What about the name on the account?
There was for this screenshot, it's in the we provided a copy of it in the record and recited. The only information that it contains is the total balance, the last 4 digits of the checking account with the previous digits X'd out, and it states that it is on a life green checking account. There's no other information provided within that initial request. It is the trial court found, and we cited testimony let me back up. The testimony at the trial court level, under direct examination, the appellee stated that, yes, there was no identifying information. There was no information that showed that he truly was the owner of this specific bank account. It is was therefore the appellant's position that after the request for compliance we had the response, the appellant or the appellee did not provide adequate proof of funds. And
Excuse me for interrupting, counsel. How was the screenshot presented and by whom?
It was presented by the appellee directly to the appellant's real estate agent through text message. To the best of my recollection, sir. Thank you. After the appellant's real estate agent received a copy of this this purported proof of funds, the appellant was under no other contractual duty that is listed expressly within the agreement that required any other response. And therefore, within a few days after receiving this, the appellant terminated the purchase agreement and proceeded to effectively just go on about his business. The trial court, we believe that the error at the trial court level occurred when The trial court's order stated, we find that the appellee, and I'm, of course, greatly paraphrasing here, but we find that the appellee breached his duty and did not provide good proof of funds. But we're still going to order specific performance of the contract. It is our position that the ordering of specific performance after acknowledging that the contract had effectively been breached is effectively the error at the trial court level. Now, the appellee in their brief says that here's an alternate timeline. We think that the first request was on such and such date, and I'll let them obviously bring that up. But effectively, by the time that the trial court orders specific performance, the contract had been terminated for a considerable amount of time.
Excuse me again for interrupting,
Sir.
counsel. Under the circumstances of this case and within the parameters of the record, how was this screenshot and proof of funds a material breach? What rendered it a material breach?
The express language of the agreement stated that the appellant, I'll substitute the specific language, said that buyer will provide adequate proof of funds, and gave examples of equity line of credit on a HELOC or home equity line of credit loan, bank statement, or a letter of credit from the bank within 5 days of the execution of the agreement. That was the express language, and it is in the actual agreement, it is in lines 130 to 137 is the express language, and that should also be contained within our appellant's brief. But since the offered information did not show that the appellee was the actual one who owned that bank account, there was no other way to effectively correlate it back to each other. So arguably, the appellee did not provide, while he contends that he provided proof, there's no proof.
The trial court found it was the failure to include his name or identify anything on any other, it was not a material breach.
Correct, sir. And it actually, in direct testimony, I believe I cited in the appellant's brief, under direct examination, the appellee admitted that that the information offered as the initial proof did not contain any information that would otherwise show that it was his. So effectively, it is.
You're asking us to hold that the trial court erred in finding it was not a material breach. Is that correct?
Excuse me. The material. Let me clarify that. The material breach, or the error at the trial court, was that even though the appellee breached the contract, the trial court found that it was not a material breach.
Yeah, and you're asking us to find that the trial court erred in finding it was not a material breach.
Correct. And therefore, because it was a material breach, the contract was validly terminated by the appellant, and therefore specific performance could not be ordered. I'll conclude my argument and wait for rebuttals.
Thank you. You have the time for rebuttal. We'll hear from the appellee.
Thank you, Your Honor. I'm Matthew Grossman of the Knoxville Bar, assisted by Michael Lee, and we'll get right to it. Let's just explain really briefly for the court who the players are here. We've got Mr. Barrentine, and the gentleman in the glasses, and Mr. Kinsler. Those are obviously the parties to this contract. And a third party we have here is Leslie Dabe. Leslie Dabe is, with respect to this agreement, Mr. Kinsler's real estate agent, his agent. Mr. Barrentine in this transaction was unrepresented. So I think that's a very important thing that the court needs to look to, is we have very basic principles of agency here. Ms. Dabe is the point of contact for Mr. Barrentine. The first thing I'd like to point out, this is skipping forward a little bit, but not on one occasion was any notice of termination of this agreement given to Mr. Barrentine until literally the 11th hour prior to closing. But that being said, let's go through the timeline here. We've got a contract date of February 15, 2021, and it certainly does have it's a cash sale, and it has the proof of funds language, which is obviously at the heart of this lawsuit. One thing I think that the parties will agree on, and it's worth verbatim reading. Buyer will furnish proof of available funds to close in the following manner: equity line on current home, e.g. bank statement, lender's commitment letter, within 5 days after the binding agreement date. Should buyer fail to do so, seller may make written demand for compliance via the notification form or equivalent written notice. If buyer does not furnish seller with the requested notice within 2 days after such demand for compliance, buyer shall be considered in default and seller's obligation to sell is terminated. Failure to close due to lack of funds shall be considered default by buyer. So what do we have here? Within that 5-day period, Mr. Barrentine, acting in the record is, to me, is clear. Mr. Barrentine, everything he did with respect to this transaction has been in good faith. I don't think anybody's accused him of acting in bad faith. Mr. Barrentine, unrepresented, within the period of time that was allowed for him to do his initial disclosure of available funds, provided that to Ms. Dabe, Mr. Kinsler's agent. And there it sat. Nothing happened. Ms. Dabe, as the agent for the seller, never came back and asked for any additional proof of funds beyond what Mr. Barrentine thought he had done to satisfy that requirement. Now, so again, this is February 19 is when that initial proof of funds was provided. Next thing, we're bumping along towards closing on March 10, 2021. Again, Mr. Barrentine, having heard nothing whatsoever from Ms. Dabe or Mr. Kinsler regarding the proof of funds, Ms. Dabe asked for additional proof of funds, and that was immediately provided. And that came in the form that was not immediately satisfactory to Ms. Dabe, but again, same day, Mr. Barrentine went down to his local Regions Bank in Florida and obtained a bank statement, and this is all on the record, provided that bank statement to Ms. Dabe, said, "Ms. Dabe, here is my bank statement with my name on it, my account number, and the total balance. Is this okay?" Text back, "Okay."
Did it have his name on it?
Yes, Your Honor. It had his name, his address, his balance. It showed that he had well in excess of the funds required to close.
So the screenshot you're saying did have his name on it?
Yes, Your Honor. Just to be clear, if the court looks at the exhibit 15 in the record and 16 in the record, it shows the chain of text messages where we have the document that provided the information, and exhibit 17 is a blow-up of that document showing precisely what information was contained on it.
At what point was that provided? Was that after a request had been made?
It was provided the same day as the follow-up, I'll call it the follow-up request, which was March 10. And basically, again, Mr. Barrentine acting in complete good faith throughout this entire transaction. And, turning to that, let's talk about good faith versus bad faith. Throughout the transcript in here, there's an undercurrent that the reason that Mr. Kinsler didn't want to sell to Mr. Barrentine is it was his desire, which was not a contingency in this agreement, to sell a different piece of adjacent property first. And when that didn't happen, there's a text message in the record where he instructs Ms. Dabe, Mr. Kinsler instructs Ms. Dabe, his agent, well, I'm not closing because I want to sell the north side first. And in the trial, we kind of developed this shorthand where the north side was the other property, south side being the subject property. And so again, I think these are all things that are coming in, running through the trial court's mind when issuing its ruling. Now, one issue that was not raised at trial, and we saw for the first time, was whether or not the requirement to provide proof of funds was a condition precedent rather than a duty. I guess the notion being that somehow if it's a condition precedent, that imposes some greater burden on the buyer and perhaps gets around the fact that this is clearly not a material breach of the agreement. Again, we believe that's waived. That wasn't raised at trial. It's not in any pleadings, not in the transcript, wasn't in closing argument. But again, we don't believe that this is a condition precedent in any event. The law, and I don't want to rehash my brief too much, but I think the most pertinent law that I can give to the court is our Supreme Court case in 1991, Miller versus Risha. Contracts entered into by the parties were conditional, and their very existence and performance depended on the happening of the contingency or condition expressly stated. That's obviously not the case here because the funds were available to close. It was not a condition precedent to closing because, as actually Chancellor Jenkins pointed out, is Mr. Kinsler, you should have just shown up at closing and seen if he had the money, which would have happened. Again, as far as materiality of the breach, we think the trial court certainly ruled, we dispute the existence of a breach. We believe that it is appropriate for a party, a non-professional real estate person provides proof of funds in a form that he believes to be responsive to the requirements and receives nothing back objecting. But anyhow, let's just say that the fact that this initial screen capture, which appears in the record as a trial exhibit, let's say that that this isn't sufficient because it doesn't have the name on it, only has the last 4 digits of the account number. Let's say that's not sufficient. Let's go through what our courts have said as far as what constitutes a material breach. And it's the De Pasquale versus Chamberlain case of this court adopts the restatement second of contract section 241 as that test. And it's a basically 5-part kind of sliding factor test. And this is critically important because when you go through these, to me, there can be no basis whatsoever under this record to find that there's a material breach that would forgive Mr. Kinsler his opportunity to close, his obligation to close, that is. Number 1, extent to which the injured party will be deprived of the expected benefit of his contract. If he just shown up at closing and the money was there, he's getting the benefit of the bargain. Number 2, the extent to which the injured party can be adequately compensated for the part of that benefit which he will be deprived. I don't think he's been deprived of anything other than perhaps some ethereal notion that he's got a better proof of funds on the second go around than the first one. Number 3, the extent to which the party failing to perform or to offer to perform will suffer forfeiture. Well, that's exactly what's going to happen here if this was to be a material breach. The likelihood that the party failing to perform, or that's number 4, or to offer to perform will cure his failure, taking into account all of the circumstances, including any reasonable assurances. That's exactly what we have here. The moment Ms. Dabe, as the agent for the seller, said, wait a second, can you give me a little more? Same business day, Mr. Barrentine dutifully responds. And then the 5th one, again, I discussed this earlier, the extent to which the behavior of the party failing to perform or to offer to perform comports with standards of good faith and fair dealing. Again, there is nothing in this record that demonstrates that Mr. Barrentine acted in anything other than the utmost good faith in every aspect of this transaction. Now, also turning, I guess I will address, just turning to the issue of the condition precedent, to the extent this court were inclined to address an issue that was not brought to Chancellor Jenkins. We have case law out of this court that basically says the law looks to the spirit of the contract and not for hyper-technical analysis. That's essentially, ever since this lawsuit was filed, every defense that Mr. Kinsler has raised has been precisely that, is I think the fair inference from the transcript in this case is Mr. Kinsler decided sometime along in this transaction he didn't want to close, and by God, he's going to find some way to get out of it. It's a case of seller's remorse is what it is. And what he is asking this court, again, for the first time on appeal, not presented to the trial court, is to let him, Mr. Kinsler, out of his obligation to convey this property to Mr. Barrentine because a screen cap that was promptly delivered within the applicable time pursuant to the contract and not questioned for about 3 weeks or so somehow constitutes either a condition proceeding or a breach that would enable him to escape his obligations. Let's see here, just about done. Again, we don't believe it's a breach of contract at all. I think the information was given in good faith. It wasn't objected to, and essentially immediately upon the request for more, that was provided. We are asking that the court also, when we've made this an issue on appeal, we're asking the court to affirm the Chancellor's ruling substantively, obviously, to the extent that this court additionally finds there is no breach of contract. We're asking for that as well. That is one of our issues. And we're asking that this court remand for assessment of appellate attorney fees pursuant to the contract. And also, one thing I'd note is that Mr. Kinsler makes a request for attorney fees, not in an issue in his opening brief, but as a one sentence in his conclusion paragraph. As I unfortunately learned in the Armstrong versus Morrison case, that's simply not sufficient. You have to make it an issue if you're seeking that relief on appeal. So unless the court has any questions of me, I will surrender the last of my time.
I hear none. Thank you.
Thank you, Your Honor.
We'll hear from the appellant. Rebuttal.
Your Honor, Your Honors, the counsel for the appellee states that this is a hyper-technical analysis of the contract when, in fact, it is reading the plain language of the contract. And my contracts professor beat it into my head that you don't say plain language because if you did, there would be no reason to be here. But as the appellee's counsel read out, there was a specific duty that once a request was made upon the appellee had to comply with it in a specific written out manner, and the appellee just admittedly did not.
Right. Help me, I'm confused. I mean, there was an original screenshot sent that just included the last 4 digits of the account number and the balance, basically.
Correct.
Was the second one sent?
The second one was sent on or about March 10, and that was well after the first request had come through.
Was it sent the same day the buyer was notified that what he sent wasn't sufficient, or they didn't believe was sufficient?
Yes. So let's back up just so we don't get timelines confused. February 19, appellant makes first request for proof of funds. Appellee responds same day with a screenshot of a bank account with no identifying information. And with that, there was no other duty placed upon the appellant to state that this is effective or ineffective. That's the contract was silent as to any other further duties on that appellant. Then fast forward to March 10, there was a second request by the agent after the appellant had already terminated the entire agreement on or about March 4. So by the time we get to March 10 and the second request comes around, the appellee, yes, goes and gets a bank statement, and first they provide a copy of a check that says, okay, here's the last 4 of the digits, you can take this and you can apply it back to the original screenshot I sent you and match the digits on the bank account. Then they say, well, that's, the agent at that point said, well, this isn't really good enough, can you just get me a bank statement? Again, and in all candor to the appellee, goes and gets a bank statement and provides a full picture of that through text message back to the appellant's agent. Our argument is he should have done that at the February 19 request. So the idea that The appellant in this case is seeking to get something that he otherwise was not entitled to through a hyper-technical analysis of the contract, is simply just reading the language in and of itself of the contract. The appellee was supposed to provide a proof of funds within a certain manner and gave examples of that, because remember, even though he was unrepresented from a real estate agent perspective, these forms are standard MLS forms that the state of Tennessee has said are good for either represented parties or unrepresented parties. So it gave examples, and the appellee's counsel read out, these are the types of examples that are allowed to provide good proof of funds. If the appellee had any question of whether or not the proof was good within that intervening amount of time prior to close, the burden was on them to ask. The appellant was under no requirement at that point to say the funds were good or the funds were bad. And regarding the notice of termination of the agreement itself, that was given to the closing agent on or about March 4, and I believe that we addressed that in our reply brief. And finally, the appellant's reason for selling or not selling is irrelevant. If the contract allows for termination for failure to provide proof of funds, the reason therefore is irrelevant. Any questions?
I hear none.
Thank you, Your Honors.
Court's thanks to counsel for both sides. We appreciate your argument this morning and your briefs on this. Thank you. Okay. Call the next case, please.